Of course, in the backdrop, the former president also has one more sleep before arguing his case to have his 15-month sentence rescinded. The Constitutional Court will tomorrow hear his application to have his prison sentence overturned. In the last couple of days, as you've seen, protesters believed to be acting in support of the imprisoned former president have torched over 24 trucks in KwaZulu-Natal. The State Capture Commission of Inquiry has filed papers at the Constitutional Court asking it to dismiss with costs Zuma's application. What are the prospects of the former president's success tomorrow? Let's unpack this now with legal analyst Advocate Romeo Nthambeleni. Advocate, always great chatting to you. Thanks indeed for making time. I want to begin with the optics that center Deputy Chief Justice Raymond Zondo. Is it a far-gone conclusion that he has to call it recuse himself from tomorrow's proceedings?
Yes, definitely. I think given the nature of the proceedings and that the applications were, the application on its own was brought by the State Capture Commission. I think he knows very well it's not going to be even an issue of debate that he's not going to sit as part of the judges that is going to actually hear that application. So I'm definitely sure that tomorrow you will never see Judge Zondo as part of the judges that are going to hear the application. I believe the very same judges that had the application the very first time will be the same judges that will be hearing the application.
Right. That out the way, for those who are still struggling to place when a rescission application is actually heard, what are the bases upon which someone can bring something like that forward? My understanding is that there needed to have been a factual error in the initial judgment for a court to even consider rescinding it.
Okay, very good question. I understand that you're asking. What happens with rescission applications? They are brought in terms of Rule 42 of the High Court rules, which have got a very stringent requirements in terms of when can one bring rescission applications. At this juncture, they're being read with the Rule 29 of the Constitutional Court rules. So Rule 42(1), a request that a court can mere mutu rescind its judgment when the following basis has been established. One, when there was a judgment that was granted erroneously in the absence of the party. Two, when there was a patent error granted on the order that needs to be corrected. And thirdly, that patent error must be common to the parties. So that's a very stringent requirement that is required in terms of the rule in relation to the rescission. So I've read the papers that were filed by the president in the Constitutional Court. The million-dollar question is that do they pass the test? I don't think so.
In the backdrop, the State Capture Commission of Inquiry has also filed opposing papers. Part of the terms that stuck out for me is them saying that Zuma is in aggravated contempt of court. I presume that this is in reference to the fact that he missed that 5-day deadline to hand himself over as per the instruction of the Constitutional Court. How much would stuff like that act against the former president tomorrow?
Yeah, look, there is a history here of a non-compliance with the law and the rules relating to the former president. So this definitely, as you have correctly pointed it out, does not work in his favor, because had the situation would have been different. You could be arguing differently to say that upon the issuing of the order by the Constitutional Court, the former president complied. But you saw that even what is now imminently called the handing over of himself is not actually the handing over of himself, because the South African Police Service had to actually intervene to make sure that they themselves are not in contempt of the Constitutional Court order as well, because it was going to affect them in a very bad light, because they were definitely going to be in contempt. Instead of him handing himself over, there was a press conference that we all are aware about, where he addressed the people. So the counsel for the State Capture Commission also in the Pietermaritzburg proceedings have argued that he was recalcitrant, and that is what formed the basis of saying that there was non-compliance with the rules of the court. And what is important, which one wants to see salvaged, is the rule of law. That should see the order of the day at the end.
Yeah, talks now of the former president possibly considering taking this even higher to to places like the African Court of Human Rights. Again, is the ground fertile for that to be a possible successful channel to explore?
Yeah, Ayanda, you know what, that is a very difficult one. I think, I don't know, from the legal advisors and the people that are advising the president as to what are his prospects outside South Africa, because I also had international courts being mooted out. So I'm not sure how that will pan out. But insofar as our local remedies are concerned and the courts in South Africa, it has been confirmed that the Constitutional Court is the apex court in the land, and the decisions of the court require finality. And you don't want, as the Constitutional Court, to start opening the floodgates, because let's not forget that this might not actually have an impact on the former president himself. There are people that come to the Constitutional Court, and the moment you grant that order, you are opening a floodgate of so many applications that will be coming. So orders in terms of the law require finality. And we know that the Constitutional Court of the Republic of South Africa is the apex court in the land. And the international courts and other remedies, we can only cross that bridge when we get there. If ever, there will still be that kind of litigation going outside, the borders of South Africa. And the higher you go outside, obviously the test will be even much more higher, for you.
Absolutely. Advocate Romeo Nthambeleni, always great chatting to you, sir. Thanks very much indeed for making time. Advocate Nthambeleni is a legal analyst.